We are live.
Okay, good morning. It is May 14th at the Senate Judiciary. We are going to get a general overview from lead counsel on S-193. It is currently still in the House and still subject to whatever changes they might make. But in order to avoid rushing at the last minute, I think it's important that we start getting a refresher and also getting an idea of the general directions that the House has gone. Again, with the understanding that they could make policy changes over the next couple of days, but hopefully we'll be getting this bill back within the next day or so that we can resume our work on it. And with all that being said, Eric, if you want to provide us that general overview. I know there's a lot to the bill, but whatever you think is essential for us to understand would be great.
Sure. Good morning, Eric Fitzpatrick for the Office of Legislative Counsel, here to talk with the committee about S-193, the forensic facility bill that, as the chair mentioned, is in the House at the moment, but is getting close, I think. So to give the committee some early indication of what the contents of the amendment might be. Of course, as the chair mentioned, also could still be some changes, but I think you could at least sort of get a sense of what, before looking at some of the language, some of the big picture differences at this point. And before even mentioning the differences, I should also say that I think that the process, you may recall that the process for S-193 was someone found incompetent to stand trial or not guilty by reason of insanity for an offense that's punishable by life in prison. In that sort of list of qualifying criteria, a person would go to the forensic facility. So that was and then there was a lot of legal process, the court proceedings that have to occur before the person gets to the facility, what findings the court has to make in order to keep the person there, periodic reviews, that kind of thing. I think that sort of overarching process you'll find is going to be very, very similar to the Senate bill. That's not really so much where most of the differences lie. And the differences, although substantial, are really sort of a handful, can be nutshelled fairly clearly. But in terms of that legal process, the House version so far, probably will come out this way, adds a lot to it in terms of detail, in terms of specifications about what things have to be found at the given hearings, add some timelines, that kind of thing. But it seems more to build on what the Senate did as opposed to having any major policy differences in that particular part of the bill. So, and we'll look at some of that, but I think you'll notice that it seems like it's longer, but it seems like more like it built on what you guys did, as opposed to, with one exception, which I'll mention, any real contrary policies. Where I think the differences are, at least the most noticeable ones are, in terms of the operation of the forensic facility. What the House is looking at so far, again, over the next 24 hours, things could change, but it certainly seems like that the House version has a much more limited role for Department of Corrections. So the House version has instead of it, you may recall it's DOC that runs the facility in the Senate. It was DOC operates it, DOC runs it. In the in the House bill, it's Agency of Human Services. And it specifies certain responsibilities for other departments within the Agency of Human Services, mental health, DAIL, Department of Health, and it has a very limited role for DOC. And DOC can provide some security, actually, even specifically around the perimeter. Emery, for some reason, I'm not able to sign in.
Please check your email.
Oh, okay.
Send you the wrong.
Oh, okay, gotcha. Thank you. The distinction in that area is that the DOC role is carved out. You'll see that in the language as being, like I'll read some of the language. Department of Corrections shall not operate or staff the forensic facility, with the exception that employees of the DOC may provide security services for the facility around the outside perimeter if it is co-located on the grounds of the correctional facility. And all that sentence I just read, you'll see it's in the legislative intent. But it also appears in the bill itself. So that's kind of the big picture difference.
So, quick question, Eric. So the way that reads then, I know WellPath provides those services. They're looking at extending those services to provide these psychologists or whatever else. So as long as DOC is now simply doing the supervision of the individuals in this front facility, it'd be up to AHS or Department of Health not to provide those clinical services. So we're saying that DOC's budget should increase because of this?
I didn't, what was it about the budget part of, I didn't quite follow that piece, but
Original in our bill, DOC was going to provide, and they're going to contract with WellPath to provide those services. So now that DOC hasn't been tasked with that, this is now going to fall on AC Human Services or Department of Mental Health to provide those services.
I think that, and that's a good question. I wonder, because I think, because that piece about contracting out for services, remember it was BGS that was allowed to do that.
Right. I don't want to get ahead if that's in there.
No, that's fine, but it's a good question. Way it's set up, I think that AHS and the other departments other than DOC that are handling these services in the House bill would probably be contract out as needed.
So it's falling on them then, provide the service.
Correct. It is following up, and that part is specified. Those are the departments that have to cover it, not DOC. So a policy decision, obviously, but that the approach that it took.
So where would the facility be then? Or are you getting to that?
No, it doesn't say anything about, you mean physically?
Yeah.
That part isn't, it's the same way, I think, as it passed the Senate, that part wasn't specified.
So would it? Okay, so if it's silent on that, then would it potentially be in southern state, but DOC would not be able to be in the specific wing in which these folks are being housed?
I don't think that the physical location is specified with that level of detail. So that, in other words, the sight and sound sort of, for some reason I'm getting an echo here. So I'm trying to do this. That's for now. The physical location, I don't think is a direct with that level of detail as far as requiring it to be physically on the grounds. If it is on the grounds, I think it allows for that. So if it is fully located on the grounds of a correctional facility, then DOC can provide security services on the outside perimeter. But I think it allows for the possibility that it might not be on the same grounds. Could be, but not necessarily. Okay. So does people have hard copy by any chance?
No, I figured I didn't want to, waste 100 pages.
Yeah.
Since the bill that we get is likely going to have different language on it.
Well, I can hit the other high points. Yeah, that'd be helpful. So that's one of them, the role of DOC. Another one is that you may recall that when the bill passed the Senate, the sort of setup was that the issue of whether the person who's committed to the forensic facility is restorable to competency is an issue that the court looks at periodically. And it keeps a similar structure, the House bill does, that if the person is not restorable, then if they're dangerous, they stay in the facility. But if they're not dangerous, then they get released under supervision under conditions. The House bill, as currently stated, and this is sort of a big picture difference, is how it treats a certain population. And this population is people with intellectual disabilities who are currently qualified for Act 248, which is they would be under Dale supervision and custody under current law. So under the bill as it passed the Senate, that universe of people, if they committed one of the lifetime offenses and if they otherwise qualified, they would go to the forensic facility. Some of the House committees don't think that intellectual disability population that's currently within Dale should go to the forensic facility. So there's a,
So can I, sorry to interrupt.
yeah, no, not at all.
Somebody who falls into that category and is Dale eligible
Mhm.
and has been charged with first degree homicide. Currently, they can be under the supervision of Dale. Is that accurate?
Right, let's say they were found incompetent, even though charged with committing that qualifying crime. Then, if the court found at the hearing that it has, that when, after the person is found incompetent.
And unrestorable?
No, that would be the proposal, but under the existing law, the court would be able to find that the person was incompetent as a result of an intellectual disability. Yes, in that case, they would be sent to Dale custody. So what the proposal is, so this is one of those proposals that's still in flux upstairs, but the general perspective of some folks on the House side was that that group of people shouldn't go to the facility because their perspective is that an intellectual disability is never restored. There's some disagreement on that, but some people have that perspective. I don't have any expertise, so I certainly can offer an opinion on that. But the place where it seems to possibly be landed is that some of those folks would be excluded. Sort of similar, you may recall as the bill passed the Senate, it excluded, people wouldn't go to the forensic facility if they were under an order of hospitalization. So if they were currently hospitalized, receiving services from the Department of Mental Health, then they wouldn't go to the facility. So sort of parallel concept, the possibility that they're talking about upstairs is to take some of those Act 248 eligible people who are, because of an intellectual disability, found incompetent to stand trial, take some of them and also say, hey, they wouldn't go to the facility, they would be in Dale custody instead. And the distinct, sorry, go ahead.
No, and if they're not restorable, going to Dale custody is what you said.
It would be, it's interesting, there's kind of two spots, two places that they could end up, 2 points on the continuum when they could end up in Dale custody. One of them is what you just said. If after the proceedings for restorability occur, when someone's already in the forensic facility, remember the court looks at restorability either every 6 months or when the Human Services medical director says you got to look at it. Yes, in that case, person's found not restorable and not dangerous, then they would go to Dale. The other group, though, that would go to Dale instead of to the forensic facility, at least possibly, still in flux, but would be at the outset. If you think about it, you might be the situation you described, Senator Hashim, someone's charged with first degree homicide. They might be being held without bail. Now, they wouldn't be necessarily be in custody of Dale yet, or at all. It could be that because of the nature of the offense, are being held without bail, as opposed to having been placed in Dale custody by the court in an earlier part of the criminal proceeding. So if they were placed in Dale custody, yes, they'd stay with Dale custody. They wouldn't go to the forensic facility. But if they were being held in the correctional facility, then the perspective there is, well, if they're going to be held without bail pending the trial anyway, then it's better for them to go to the forensic facility when you're going to get competency restoration services, when you're not going to get that in the DOC facility. So that's the distinction they made. If they're going to, well, possibly are making. The person that in being held at a DOC facility pending trial, then they go to the forensic facility.
So I guess I'm maybe a little bit confused. Maybe they made some other changes, but my understanding is that this would only apply to people who are being held without bail in the first place. So if somebody is being held without bail and they have an intellectual disability and they're not restorable, when would they go to Dale if they're being held without bail?
Well, there was, remember, as the bill came out of the Senate, there was an additional piece whether the person wouldn't necessarily be held without bail. They could be, remember we added to that
Oh,
piece,
right.
not
Right.
held without bail, you know.
And the second piece, what was the, I remember.
It's if the person's not held without bail, they have a qualifying condition that upon their release would create a substantial risk of bodily injury to another person.
Okay, right. And
So
those
that's
are,
the group they're talking about.
okay, that's in a very narrow,
Right.
almost impossibly likely situation. So
Right.
that makes more sense.
Yeah.
Thank you.
But yeah, otherwise, I think, you know, you would think that in the vast majority of these cases, you know, a person is held without bail for a life offense if the evidence of guilt is great. In many of those cases, that's what's happening. And if that's the case, then yes, they'd go to it. I mean, yes, they'd go to the forensic facility.
Okay. That's workable.
Right. So that's one of the other, if not, so those are that. I mean, main changes are the role of DOC, the role of Dale that we've just been talking about. I think I'm missing one. Well, it does that. So it adds, it's related to this Dale custody issue. But the related piece is that the court is allowed, it's sort of an off ramp later on in the proceedings. And it's kind of what we were just talking about, Sarah Hashim. If the person is found later on to be, when the court does this restorability evaluation, which it has to do every 6 months or when requested by, and that's another thing. Every time you see Department of Corrections, it's replaced by Agency of Human Services or the Agency of Human Services medical director would be the person responsible for the provision of competency restoration services and all the treatment, that kind of thing. So it would be that person who is reviewing the status of the defendants and responsible for overseeing the opinion about restorability, that sort of thing. So if the court decides at that stage of proceedings later on, when the restorability issue is considered, and the court finds the person's not restorable, not dangerous, then they would also have this off ramp to Dale. So again, that's theory being there. If that's the case, the court's found not restorable as an intellectual disability, the right services are in Dale, not the facility. Okay, so. And there's a lengthy couple of pages of language as to what the court has to find to send the person to Dale in that situation, and how there's a back and forth between Dale and the court to determine whether or not they have an appropriate placement for the person. So that is all new.
So I do have one question here. I hate to go backwards, but could you go back to the role that DOC may play in this particular? Is it somehow on the outside or whatever? What was that?
Yes.
Could you read that again, please?
Yep. The Department of Corrections shall not operate or, well, let me actually read the sentence before, just so you can see what it says. AHS does, the other departments within AHS, for example. That Agency of Human Services shall establish and operate a locked, secure forensic facility for the competency restoration, evaluation, stabilization, treatment, and care of persons who have been found not competent to stand trial or NGRI, or serious criminal offenses. So that's what AHS does. But then, you know, that includes DOC, right? So that's why the second sentence specifically says what DOC can do. The DOC shall not operate or staff the facility, with the exception that employees of DOC may provide security services for this facility around the outside perimeter of a forensic facility, if it is co-located on the grounds of the correctional facility. So basically, I think the thought is that DOC shouldn't be inside the building.
Well, I can see that. I don't have a problem with that, but my concern is, what does that mean exactly? Because rather presumptive on their part to say, okay, we want to put a walkway in around the facility so DOC can I mean, my concern would be for the safety of those individuals offering those services within that facility, and how would, in this particular case, DOC be contacted or respond to an individual who's being disruptive or whatever, shall we say?
Yeah,
Because we don't know where the facility may be. If there's going to be a facility that we're already placing them someplace outside of this facility that doesn't exist. My concern is simply the safety of the workers within the facility. I'm not saying put DOC inside the facility, but some type of a monitoring booth, I would think that they can at least view and not have contact unless obviously necessary. That'd be my concern, I guess.
Yeah, coming in a similar vein, I think some of the conversation that we had when we had the bill was the therapeutic environment or lack thereof inside of a correctional facility. And, you know, it's finding staff for almost anything is challenging to begin with. So I don't know. I mean, I'm wondering if, you know, rather than completely prohibiting DOC from being inside the wing or the facility, is there a way of making it so that the people, if we were to permit it and allow DOC workers inside of the facility, that maybe they're wearing plain clothes rather than the uniform that you see wearing DOC staff, or the DOC staff are wearing, or you know, maybe they go through some additional training that is more focused on the niche services that have to be provided in what is supposed to be a more therapeutic environment rather than a carceral environment. Just some thoughts.
no, I think you guys are definitely identifying one of the policy differences that you have to work through. Anything that you decide you want to do, we can certainly put in the language, however you want to craft the division of responsibility between DOC and the other departments within the Agency of Human Services. Once you think through what the right role and balance is, those amendments can be done. I'll read
At the
it.
very least, I'd like to see them have the ability to at least monitor.
Yeah.
You know, if you want to go as far as say, put them into the wing or whatever with plain clothes, I mean, but they should be able to have the ability to monitor any disruption or potential safety concerns.
Yeah, or you know, maybe keeping them out, but if there's an emergency,
Right.
you know, if two people are fighting in the facility or something, requiring that they remain outside and you know, unable to do anything, I don't think makes a lot of sense. You have any thoughts?
I have a lot of thoughts, but none of them are gonna be helpful in this conversation.
Okay.
DOC shouldn't be involved. I mean, if there were a fight in a hospital, you wouldn't call DOC.
Well, DOC isn't involved. You'd call it security, right?
You might call the security, you might try to de-escalate it, there's a whole host of things that could be done. But I'm far more supportive of the House language. Not that I'm sure that doesn't come as a surprise.
Any
And
thoughts?
I don't think putting a correctional officer in a polo shirt makes them a therapeutic. Like, that doesn't create a therapeutic environment.
I mean, is it better than the correctional uniforms that they're already wearing?
I mean, I suppose it's slightly less off-putting, but they're still a correctional officer not providing therapeutic services. I mean, I know when I was in the House and we were hearing about the staffing crisis within DOC, because I also questioned if DOC even had the capacity to take on more. But one of the things I heard over and over and over again from the DOC is we are not social workers. We are not mental health workers. So I don't know that changing their uniform suddenly makes them mental health workers.
Yeah, no, I'm not. That's a logical fallacy that I wasn't presenting. I'm not suggesting that DOC becomes social workers. I'm trying to make sure that we have a bill that actually makes sense. You know, I think that if two people are fighting and you have a security guard right outside of perimeter, they should be able to intervene if de-escalation doesn't work. And, you know, you had previously raised that correctional facilities aren't particularly therapeutic environments, which I agree with. And so I'm trying to find ways of making it more of a therapeutic process rather than this carceral environment that we had some concerns about. All right, thank you, Eric.
Yes, one last thing, just because it's another substantive difference on a different topic. You'll see it obviously when you review the bill, it comes down, but just to forecast it for you, one other distinction is that in the NGRI, not guilty by reason of insanity population, there's a review process. There was in the Senate bill as well as there was for the folks who are found not competent to stand trial. And the review is periodic. But you may recall that for that population, because it's different than the folks who are found not competent to stand trial, because those folks have just recently had a competency evaluation in the criminal division before they went to the forensic facility, as opposed to the NGRI folks who are being held when there's no more criminal charges pending. So the Senate bill required an initial evaluation of that population very quickly, within 48 hours after their admission to the facility. The House changed that to 60 days, thinking that there needed to be more time for that. And the periodic review in the Senate version was the same as for the folks who aren't competent to stand trial, which is every 6 months or whenever the medical director certifies that it should be done. And they extend those periods for that population only as well. So that the first one is 6 months later after the 60-day period. But after that, it gets spread out to a little bit longer, actually fairly substantial longer. So after that first 6 month period, it becomes 3 years after that, then 5 years after that. And then the person themselves can also file during that window for an additional reevaluation. So they extended some periods, just so, because wanted to make sure that when I was saying most of these policies in terms of how the facility is, the legal timing of the hearings and all that are mostly the same, which is true. That's one of the ones they just to get about that. And I think that's the big picture of what most of the differences are currently. It could change. In fact, it's being taken up this morning upstairs as well, so it could be something additional.
Let's see about 40 bells to 60 days.
Yeah.
Yeah. And if I recall, so this is the not guilty by reason of insanity. One of the conversations that we had about that is that someone may be deemed to be legally insane at the time of a crime, have gone through treatment and now not to be. So they may be found not guilty by reason of insanity, but no longer be suffering from whatever at the time of the verdict. So they are now in this facility for 60 days where they may need to be there.
Right. Or potentially not dangerous. But that's the other thing that has to be part of the finding. But yes, yep, that's right.
Okay.
Yeah. I suppose, actually, now I think, but I've said this with respect to that's what the key point is, potential, because it's also potential, because the medical director always has the ability to certify at any time. Hey, I think in the competency universe, hey, I think this person's not restorable. Or, hey, I think this person has regained their competency. They could do the same for the NGRI population. But I think you were saying, but it's still possible they could be there for the 60 days. Without that, that's the future. Yeah.
60 days is way too long.
Yes.
Okay. Thank you.
Yeah, absolutely. I'll keep you posted. Yes.
And get to go on that.
Okay.
Yes.
Morning. Rick Sabel with the Office of Legislative Counsel. I can zoom in, or you guys have the printouts look like either way.
Yeah, you can put it on the screen. That might be helpful.
So 209 is back from the House. This is the bill that, on the civil arrest, the census spaces bill. It is a strike all because there were some changes that would make it hard on the instance of the amendment to structure correctly. So I've highlighted on the side by side, which you all should have a copy of, the pertinent changes to the version that passed the Senate. And I'm getting into the Zoom here where I'll show it to the screen. So no changes to subsections A or B, which you didn't have any changes either. That's existing law. So those stay the same. Subsection C is the prohibition, and that is where the changes do appear. Okay, here we go. So the prohibition intro language stays the same, but there is a pretty major adjustment here where the language begins, a person shall not be subject to civil arrest while, that's the House version on the right. On the left, the Senate version kept the statute as is, that kept the language while traveling to, entering, remaining at, or returning from a. So on the House side, court proceeding, which is under current law, remains that traveling to, entering, remaining at, or returning. And the House put educational institution also in that scope of traveling to, entering. The other remaining locations are now subdivision B on the premises of. So there was discussion in the committee about the maybe difficulty of law enforcement knowing if somebody's returning from a library, returning from XYZ location. The belief was that the court proceedings and schools tend to have certain requirements, when to be there, when not to be there, and that's why they decided to break those out.
So just to narrow it down, it's they've added the state buildings, they've added the DMV and the public library, but they have taken away from those sections the concept of traveling to or from, right? So you have to be there.
Right.
Okay.
Right. Except for court proceeding and schools, those are still returning travelers.
Senator Mose.
So I do kind of, well, I may not agree with it. I understand the logic there with everything but the healthcare facility. So as this is written, if someone were in an ambulance on the way to the ED, could that ambulance be stopped and have them be civilly arrested with no warrant?
So, right, in the ambulance, that would not be a sensitive space, not until they arrive at the healthcare facility. So continue the new language here on the first page. So yes, the House Judiciary added and this is language you all considered. They worked on it a little bit, trying to make it more clear. They had the same discussion about the National Life Building, about the salt sheds. That same discussion came up in the House Judiciary. So they landed on BI, which is building owned and wholly controlled by the state or a political subdivision of the state, where members of the public may enter in order to conduct governmental business. So that would not include a building that has a state office with other private offices or residential locations. So National Life is a easy example of non-failure. That is not a building wholly controlled by the state because it's owned by National Life. The state leases out offices.
Is the same true in sort of the reverse where the building is owned and the state just leases? Although that is exactly.
They would wholly control it, right?
So like the DCF offices in Williston, that also has a physical therapist in there. Those DCF offices, if someone was there meeting with their DCF worker, they would not be protected.
As long as the building is owned and controlled by the state. I don't know specifically that location, but the state owns the building and they can lease out certain tenants. But if the state owns the building, that would be, to my read of it, sufficient for.
The state does not own the building. They lease the DCF offices in the building. It's owned by a private.
That is not easy. They added Romanet II, which is an office operated by the DMV that is open to the public. So my understanding is that like the Montpelier location is a state building owned and controlled by the state, but there may be some locations that are leased by a private entity that the DMV uses. And so that specific type of location would be a sensitive space, the DMV locations. Romanet 3, public library is added, and there's a definition that cross references from our law at the end of the bill that defines what a public library is. Polling place was kept as is. Subdivision V5. One change at the end of that list of a social services establishment, replacing in the Senate version, it was an establishment distributing food or other essentials. The House changed that to a food pantry or similar establishment that distributes food. I believe there was discussion about grocery stores potentially being included in that, so language was amended to avoid that confusion. Place of worship was kept. The other change in this list is in the Senate version, FI, a facility regulated by the Child Development Division of the Department for Children and Families. There was their belief that this captured private after school.
Sorry, where are you?
I am on FI. Sorry, right there.
Back page.
Senate version. So the facility I regulated by the Child Development Division. So again, the committee had the understanding that that was a more a private facility that sometimes can be someone's home, doesn't have to be, but it could be that if it's a private residence, they already have the right to not allow, law enforcement without a warrant into their house. With the understanding.
So they took that out of the Senate version?
Right.
With the rationale that there could be a home that's regulated by DCF, and therefore the owner of the home could deny entry?
There wasn't a whole lot of debate about this, I'll just be honest. But to me, the understanding was that they didn't want to loop in foster homes or other potential private residences, which already have center homes.
But that doesn't, there are places that are not homes that would be regulated in this way, correct? That are child care facilities being run not out of someone's home. Like yeah. That is.
I assume that's correct. I think they felt comfortable with the education institution if it's at a school, which they're not all connected to schools. But that's, I think, where they landed.
So the child care facility and after school program that is run not out of someone's home. I'm thinking of, there's one in my district. It's standalone. It's not at a school, but it's not at someone's home. That would not be covered because this has been put in or taken out.
Right, unless it's so, on the house side, they did leave in the children's camp. I don't think that would meet that type of care. If it's just an after school program after school in a non-school location, I don't believe this bill would deem that a sensitive space.
Okay. Because there's actually quite a few of those that are not at a school. All of the ones in Essex are run at the local park.
Okay, so no other change to C1 or C2, the exceptions. The remedy section does have, I'm gonna highlight this, I don't highlight this. There is a change here, it was the bills that passed, under 3A, and it doesn't show because this was not, it didn't carry over to the process for some reason. So on the House version, this or assisting with was struck. So a person who violates the subsection by knowingly and willfully executing an arrest prohibited by subdivision 1, which is all the sensitive locations. So again, I think the understanding was that the committee did not want a aider and abettor, someone that gets caught up in a civil arrest, helping perhaps law enforcement to be subject to some type of lawsuit. So that those 3 words were struck in the House version. And this is existing law, so this is in statute. Okay. And then the only other thing for definitions that were added.
Public library and
Public library, and so in the Senate version, the definitions were cross-referenced and the prohibitions themselves, and they wanted to have this all at the end to have uniformity. So all the definitions are cross-referenced: healthcare facility, polling place, public library. Those are all reflected at the end of the statute, but no change to the actual text of the definitions.
great, thank you. Any additional questions for Rick? Right, so this bill is back from the House, and so I have some initial thoughts on some potential amendments. So we are going to hold on to it just a little bit and then we'll send it back next week. I always get confused by this, but we're able to make one last set of amendments for this, but we can send it back with further amendment, right?
You can.
Yeah, that's what I thought it is. Okay, great.
And it would be an individual amendment at this point because you don't have the bill. It is not been recommitted to, unless you ask the Senate to recommit it to your committee. So it would be Senator XYZ. It could be multiple senators that make the amendment.
Right. Okay, thank you.
Sure.
Appreciate it.